Okay, good afternoon, everybody, and thank you so much for joining us today. Welcome to Fraser Jones Irish Employment Legislation webinar. This is the second in our series featuring the wonderful Hilary O'Connor. My name is Claire Schindler, and I'm the Regional Director for Ireland here at Fraser Jones, and we're a global specialist HR executive search and recruitment consultancy. And at Fraser Jones, we place talented HR professionals with all types of organisations, from startups and SMEs to global FTSE organisations, and we support both permanent and interim projects. I lead the Irish business, and I've been in the recruitment industry in Ireland for over 25 years. Fraser Jones has global reach. Along with our office in Dublin, we also have offices across the UK and Europe, the US, Asia, the Middle East and Australia. So we're uniquely placed to support global organisations with all of their HR talent requirements. As HR professionals yourselves, you know that employment law cases and decisions have significant impact on HR policy. So to give us some insight, Hilary is here to review a number of very recent employment law cases and decisions. Hilary will also advise us on how these impact our own organisations and give us some tips and takeaways. I'm very pleased to welcome Hilary today. Hilary is a solicitor and legal consultant. You may be familiar with her from her series of straight-talking legal advice posts and reels on Instagram. Hilary is a highly accomplished legal professional with a keen interest and significant experience in employment law. She qualified over 18 years ago and was elected to the Law Society Council in Ireland last year. A little housekeeping before I pass you over to Hilary. If you have any questions throughout today's session, please add them to the Q&A box. We'll answer those questions at the end of Hilary's presentation. Hilary will also share her slides with all attendees, and we'll record this session for you or your colleagues to access later. So I'll hand you over. Welcome, Hilary. Welcome to Hilary, and I hope you all enjoy the session.
Thanks, me and Claire, and hello to everyone joining, and well done for taking your valuable lunch hour to go through some recent employment law cases. So we'll get stuck in and get started. I'd say the session would last about 30 minutes, and then we'll have time for some questions, and you will get back to your lunch after that. So we'll kick off. I went through the WRC and looked at the issue of reasonable accommodation. This case was a case which was decided by the Supreme Court in 2019. So it's not a recent case, but it's only 4 years old, but it is the leading authority, and it is quoted in some cases that I've looked at with respect to reasonable accommodation. And this, of course, is where there is an injury at work or there's an illness at work, and the employer's obligation to make reasonable accommodation. And so I thought it would be instructive to go where the leading authority is and where the obligation is right now. So this is set down by the Supreme Court in Nagle School versus Daly. And in summary, the Supreme Court clarified the law as follows. The employer's obligation in relation to an employee with a disability is to take appropriate measures where required in a particular case to enable the employee to continue in employment. And that duty includes an obligation to consider relieving the employee with a disability of such duties as they cannot perform because of the disability. There's no distinction should be drawn for that purpose between duties and tasks, or between core duties or essential duties. And 4, the duty does not extend to an obligation to create an entirely new job. And 5, a reorganised job is not necessarily a new job. It is a matter of degree to be decided on the facts of each case. And then number 6, the employer, and I put this in bold, and this could be your starting point, a wise employer will consult with the employee with a disability before making decisions about their future employment. However, a failure to consult does not amount to discrimination for the purposes of the Act, but it is all about taking everything as a whole, really. So 7, then the employee with a disability must be fully capable of performing the duties of the position after it is modified by the application of reasonable accommodation, which can include relieving the employee of the requirement to perform certain duties which they cannot perform. And then Justice McMinimum, he commented on the obligation of the employer as follows. The terms of Section 16 of the Employment Equality Act are mandatory. They place a duty on the employer to show that if they are not carried out, if they have not carried out such a process, then it is only because the reorganisation necessary would be disproportionate or unduly burdensome. What is essential is that it is to be shown objectively that the employer has in fact given the question of redistribution full consideration. An employing entity may have to ask itself the ultimate question whether the position is in fact capable of adaptation so as to accommodate that claimant, and whether the claimant would be capable of performing that function thus adapted. But it is the position or job, not another one. If on reasonable accommodation a claimant is unable to fully undertake the duties attached to the position, then the Act provides there can be no finding of discrimination. I've put that, as I said, that case goes back to 2019, but it is the starting point. And I'm now going to go through two cases which are decided in the last 2 weeks, or the last 10 weeks since we've come into 2024. So Cian O'Sullivan versus Kilkenny County Council. So here the claimant was a general operative working for Kilkenny County Council. He was employed there since 2002. He was certified unfit for work in November 2019, and in July 2020 he attended the employer's doctor. The doctor certified him fit to return to the majority of his tasks, but not shoveling or scraping, as the lateral movement would have had an adverse effect on his medical issues. So because of that, the lateral movement element, the council certified him, or said he was not fit to return to work. Now, Mr. O'Sullivan was very keen to return to work, and he went to his own consultant who referred him to an MRI. And the consultant recommended he could go back, but not to do any, for just non-strenuous work. Mr. O'Sullivan, as I said, was very anxious to return to work, and his orthopaedic consultant had said it looked for a reasonable accommodation, stuff that he could do. So the council then decided that he could come back just for a day and a half a week, and what he was to do was to cut the grass, but that was seasonal. So he came back from June to October, and then the grass season finished, and he took annual leave, and because he had no job then, effectively, because they said he was not fit to return to other tasks, and he took a complaint in November 2021. He also was referred then in the December to the employer's consultant. So the decision here was that the complaint of discrimination was upheld on the grounds that the council did not make reasonable accommodation. He also claimed victimisation. He says because he made the complaint in November and he was sent to the consultant in the December, he said that was victimisation. But the adjudicating officer said that there was no evidence of adverse treatment because he made the complaint. The respondent was entitled to have him medically examined. So here there was an award of €15,000, which was significant. So that was that case. And then a service worker versus an online sales company. Here there was a claim of discrimination on grounds of reasonable accommodation, reduced and flexible hours, and her educational assistance program ceasing because of absenteeism. So here we had a customer service agent who was working away and working in the office, and she had decided to do a degree part-time and had worked her way through that, and that was all going well until year 3. And this coincided with pandemic restrictions, and where the complainant was working remotely and then studying remotely, and she became very anxious with the pressures of work and study and the isolation of both. And so she requested reduced hours for a period of 9 months to complete the degree. And this was denied. So she made a complaint, and she had a supportive medical report which said that she was suffering from high levels of anxiety regarding the work and study. And the medical report mentioned that she was willing to take annual leave, and the doctor believed that reduced hours should be accommodated if possible. The employer had a very strict absenteeism policy, and if you were absent, then the educational assistance program was withdrawn. So she had made a complaint to the WRC, and the WRC says that she was not discriminated regarding the educational assistance program because that was applied across the board, and but she was discriminated regarding the request for remote working, as there was no evidence that the respondent made a formal assessment having regard to the complainant's disability and the medical report, and she was awarded €12,100, which was 4 months compensation. So again, significant, but so then moving on from beyond reasonable accommodation, we're just going on to unfair dismissal, and I have pulled out 2 cases for unfair dismissal. The first is Zohab Akhtar versus Johnston Harty Retail Limited, who were trading as Daybreak. And here the complainant worked for Costcutter in 2020, and then sometime in 2021, the shop had been sold and it now changed to Daybreak. The complainant here refused to sign a new contract, and this contract was to say he was a temporary worker. The respondent reduced his hours from 40 hours a week to 30 and then down to 25 hours. He was the only one affected, and he emailed on the 13th of February 2023 to query the reduction of his hours. The following week then, he was asked to attend a meeting where he was told there was 2 complaints against him and he was suspended pending the investigation of these 2 complaints. He never got any details of the complaints, and the following week, the 2nd of March, his contract was terminated without any reason. So he was not told, again, of any of the details of the complaints. So here it's very clear there was no due process or fair procedures. There's no notice given. So unsurprisingly, it was a clear case of unfair dismissal. He was out of work for 4 months and proved that he had mitigated his loss, and he was awarded £6,000. Again, here, this was a case where the complainant had made his own application, and I think if he had gone to a solicitor, there would have been other claims made. So €6,000, which I'm not dismissing as nothing, I think that claim could have been greater had he gone to a solicitor, because, as you know, the duty to mitigate in unfair dismissal claims, which I think in a buoyant job market makes it nearly worth a while for an employer if they do want to dismiss someone, because the duty to mitigate is so great. So from a claimant's perspective, if there are additional issues, like say if there was a discriminatory matter, then there isn't the duty to mitigate there. So I think this man here, he could show he was out of work for 4 months and he had proved that he had looked for other positions. So the award is quite low. Then we contrast that with the next case, which is Mr. Mick Kiley, and this was a case which you might have got the headlines last week because it was the highest award from the WRC. I suppose to contextualise it, we're talking about a salary which is an eye-watering salary of €340,000 here for Mr. Kiley. Mick Kiley was the founder of his own company. It was subsequently taken over by a company in the US. And the relationship broke down and Mr. Kiley was dismissed summarily, and he was emailed and said, don't come to work tomorrow, you don't have a job, kind of thing. And if you come to work, you'll be a trespasser. So it was that blunt. So there was a bit of argument as to whether this was a contract in the US governed by US or Irish law. So fortunately for Mr. Kiley, it was the laws of Ireland which governed this contract, and it was more favourable for him. So the point of unfair dismissal was conceded. So then we move, once you have unfair dismissal, has been sorted, you move into loss. So how much do we owe you? We have dismissed you. It was unfair. So how much do we owe you? But don't you have a duty to mitigate? And here he successfully argued that he couldn't mitigate his loss because he was under a non-compete clause. And the respondent, the employer, tried to argue and says, but you could have moved. Like, he was living in the US, and they kind of said, well, you could have moved back to Ireland, whatever. But the adjudicator went with them and said he had claimed a loss of €478,000 for over 17 months loss of earnings. He had showed that he had set up, he had made some money from the arts, 10 grand or something. But the decision from the adjudicator was that he had a loss of 460,000, but this was reduced by 20 grand for a 5-month period post the non-compete. And then he was awarded 24,000 for 4 weeks notice, breach of the minimum terms notice. So that was an eye-watering award. But I suppose, repeating what I said, the context here is that he was earning €340,000 a year. But it's interesting from the point of view of mitigation, and where his ability to mitigate was restricted by his non-compete. So that's unfair dismissal, 2 cases there. And this is an interesting case here on annual leave and the Organisation of Working Time Act. And it's a case of Martin Byrne and the HSE. And here, this is a fairly sad case, I think, because Mr. Byrne worked for the HSE as a property manager, and in 2008 they tried to redeploy him to another department, but they were unsuccessful. So his job remained, and he managed a team of 5 people. But since 2008, he had no report line. He had no line manager. He'd nobody who was overseeing him, and which many people might think that was a great thing. And if you had no one to report to, but it did mean that Mr. Byrne was in isolation with regard to a reporting structure. And what he did was he, as he had done beforehand, he logged his hours onto the HSE system. He logged his holidays when he took holidays. But because of the nature of his work, he wasn't able to take his full holiday entitlement every year. And it certainly came across from reading the case. He was a very diligent and conscientious worker, and that's why I think it's sad that he has to go to these measures, and we'll see where he goes. So he had logged on his hours, so he had this accrued annual leave, and the annual leave amounted to 104 days. So he was due to retire in May 2022, and he emailed his employer and said, yes, before I leave, can I get my 104 days of annual leave as a cessation payment? So they said, no, sorry, you're not entitled to that. And that's what they argued when he took his case to the WRC. And they said, no, you're not entitled to that. Now you're entitled to the leave of the year plus 6 months, as Section 20 sets out. The decision here, the adjudicator found in favour of Mr. Byrne, and they relied on an earlier case, which was this case of a facilities coordinator versus a bakery, where it was held that where an employer is on notice of annual leave not taken and fails to advise the employee that unless the annual leave was used, then it's lost. So in those circumstances, the annual leave accrues. as an entitlement on cessation. And as this did not happen here, he was entitled to it. So the award was 104 days or €31,666.78. So expensive for the employer, but because it's a very unusual case in that it isn't often you'd have somebody with no reporting line, no oversight whatsoever. But the point is, if you're on notice, and the HSE was on notice here because he logged his own hours and he logged when he took annual leave, that he hadn't taken this annual leave. And so I thought that was an interesting case. I say it's sad because he was so long in his job and he had to make this claim. It's just a bitter way to go out. Also, just in advance of the second day of this case, he had just settled his travel and expenses claim with the employer, and that was to €80,000. So he was an incredibly trusting person to let these bills run up. But it is it's a bitter way of ending your employment relationship. So that's that one. So then we move on to the gift that keeps on giving, which is retirement. And where are we with this? Yes, so this is much litigated, and it's become more and more of an issue because we have an older population. People are living longer. People are healthier. And we have our state pension, which is the entitlement to the state pension is rising. It's now 66. And since January, we have a case where we can defer the pension, the state pension until 70, would you believe? And if you're interested, and continue working in return for an advanced or an enhanced state pension. So that's what the government's response to this is. So all of these matters, the fact that we're living longer, we're healthier, we've got an older population. This is putting pressure on the coffers of retirements, of pensions, both state and private pensions. And people are going to pensions, or they're not entering the pension market early as they should be, and they are finding themselves coming up on retirement age thinking, oh Jesus, I don't have enough money for retirement, or I don't have enough to bridge the gap between the state pension and when I retire from my job. So that's the backdrop to why we have so much litigation in retirement age. So we're back to the slides. I digress. So the retirement age is permitted. So it is legal to put a retirement age in your contract as long as it's objectively justified for a legitimate aim in setting that age. That's what it comes back to, objectively justified for legitimate age. So the onus is on the employer to establish that there is a compulsory retirement age, and it is incorporated into the terms of the contract, and it is known by the employee. So if the employee wants to work beyond an age specified by the employer, you must deal with it, having regard to there's a code of practice on longer working, and I have, where am I? Back to Mr. Byrne. So there is a code of practice on longer working, and I've given you the link there. So employers should engage with all employees in advance of retirement in accordance with this code. Now that is important, and I have discussed a decision, a recent decision where it does kind of highlight the importance of this code. The employer must consider the objective justification for keeping the employee on if there is a request. And the request must be considered on a case-by-case basis. Again, that's important that you have looked at the individual's job. You're looking at your own needs as an employer, and you're not just making sweeping statements and saying, no, we must consider it. So a workaround, some employers are using as a workaround this fixed term contract, which can, of course, work for, if it was 1 or 2 years. But you need to be careful about using fixed term contracts if if everybody's using, or if you use fixed term contracts for every one of your employees, then there's an expectation that there will be a fixed term contract granted. And then that kind of undermines your retirement policy. So it is a balancing act. So that's the backdrop for retirement. And I have just gone through a couple of cases. We're actually flying through all of this. Everyone will be delighted. Or people are saying, oh God, you're still talking. Maybe I'm not. Anyway, we go on to Carl Davidson and Mary Ireland. So this Carl commenced working in April 1994 as an aluminium specialist on a sales team. He had an unblemished record for 27 years. His contract said retirement age is your 65th birthday, which for Mr. Davidson was the 22nd of September 2020. He requested an extension and he was granted a 1-year fixed term contract. Then the following year, in August 2021, he made another request for an extension, but this was not granted, and he was told he did not meet the age profile of the company, and therefore they were enforcing their retirement policy. So he brought a claim under the Equality Act, and the comparator was the managing director, who was still working, and he was not a shareholder or an owner, and he was 70. So the respondent here advised that the MD was an exceptional measure where he was seconded to another company at the request of shareholders, and this was an exceptional situation rather than the normal policy. Here the decision was the discriminatory claim was out of time because he retired in September 2020. Then after his retirement, he freely entered into a fixed term contract. So he could have raised the retirement issue back then, but not now. And the request for the renewal was refused, and the discriminatory claim brought in February 2022, which was almost 17 months after the issue of retirement age. So that's one decision, and we can contrast that with Deborah Toland versus Lifford Credit Union. Here, Ms. Toland was employed as a teller from 2000. She claims she was discriminated on the grounds of age by being forced to retire at 65 in 2021. Her contract says you shall retire at 65, and it may be extended past 65 by mutual agreement. She had requested in the November to her manager and says, I'd like to work beyond 65. And the manager says, yeah, sure, I'll talk to the board. And he didn't. And then she emailed in the February and requested it. And she was told in March, I think, no. And then she appealed it. And then in April says, no, this is not in line with our succession planning. So she argued the respondent was in breach of this code that I talked about a minute ago for longer hours. They had not engaged with her or retiring staff in breach of their obligations under the code. Now we have a nice wordy slide here, and this was the decision. The adjudication officer says the code of practice on longer working sets out best practice for managing the engagement between employers and employees in the run-up to retirement age within the employment concerned. While I note that the respondent was dismissive of the significance of the statutory instrument, the code of practice references notification procedures, the carrying out of objective assessments in the context of justifying the retirement and access to an appeals mechanism, none of which were, none of which were observed, that should be observed, by the respondent in the instant case. The claimant should have been given adequate advance notice of her retirement, of the respondent's response to same, and should have been afforded an opportunity to test the justifications advanced by the employer in advance of a decision being made on her request for an extension. Additionally, to comply with the code, the claimant should have been afforded access to a proper appeals process. In this case, the claimant appealed to the same body that made the original decision. So here, that was the significance of that code is certainly borne out by that decision, and she was awarded €25,000. So it's significant when you don't get it right. Okay, so that's that case. And then so legitimate aims that I've just kind of gone back over to cases which have said, yeah, it's okay if you're promoting access to employer for younger people. Again, these needs to be your legitimate aims. They need to be objectively justified, intergenerational fairness, etc., and providing patient safety. So I've just left those there. And then, of course, another, as I was doing these slides, then I found another one, and I was like, oh, I'll put this one in. I went down a retirement age rabbit hole because I'm sad. Okay, so Thomas Doolan versus Air Business Aircom. And this again, I think is it's a little sad. Here we have Mr. Doolan. He commenced employment at 61 in 2019 as a desktop support agent. He was advised in January 2023 that he would have to retire in July when he turned 65. Again, that Air Business here seemed to be, you know, in line with the code that we talked about a minute ago, because they were writing to him and says, you're going to retire in July, which is in compliance with the code. So he appealed this, and in March 2023, the decision was upheld. He claimed that this was discriminatory, as he was doing a job he loved very well, and he wanted to continue to do this. That's why I think it's kind of sad, because he loved his job. Anyway, you can tell I'm a heartstrings person. So here we go, back to the adjudicator. He considered intergenerational fairness and succession planning arguments put forward by the respondent. However, he noted that the claimant's role was not one that could be described as safety critical and was junior and would not interfere with the aims of the retirement policy, considering the non-critical role he did. So that's where the adjudicator put the emphasis on here. And this case here, the adjudicator ordered reinstatement, as that is what the claimant had requested rather than compensation. That's why I thought it was kind of sad. I was like, he just wanted to go back to work. He didn't want money for nothing. So anyway, that what was ordered there. So that's retirement and all its pitfalls. Other matters of note this year. So as you know, we had the Work-Life Balance Act last year. That parts of it came in in April, and then parts of it commenced in July, and others in November. So we are waiting, pursuant to that, we're waiting on the right to request flexible and remote working, and the WRC are supposed to publish that code. We expect it by the end of January. We're here at the end of February and we still haven't seen it. So soon, that will come soon, and it will, I'd say. It'll be in this quarter. But when that's published, you will have to look at your own code or your own policy on flexible and remote working, because I would say for certain you will have to amend it in accordance with the code, because the code will be best practice. It'll be what you have to consider. It'll be the go-to. So once that comes out, have a look at your own policy and make sure it's amended, because the code will now be the best practice. Yes, so we'll probably need to amend. Yes, okay. And if you fail to have regard to this code, you know, then they can make a complaint to the WRC. So the last bit there, yeah, sorry, just the last bit of updates. It probably shouldn't be on the same slide, but now what is after happening? Bear with me. It's the last slide. Yeah. So yeah. Other items of note for this year: Sick Pay Act. Last year it was the statutory sick pay was 3 days. It jumped from 3 days to 5 days this year. And next January it'll go from 5 to 7. And January after that, 10 days. I mean, that's all forecasting. That's all something employers need to be aware of, that this is on the increase, and your obligations increase on this. We also have had an increase in the minimum wage from 11.30 to 12.70, and I'm sure you're all aware of that, and aware of all the pressures that come with the increase in the minimum wage. And then also later on in the year, we'll have the auto enrollment into pension scheme, where employees are automatically enrolled into a pension scheme. So you should liaise with your pension providers in that regard to be kind of ahead of what's coming, because that will be another obligation on you to facilitate that. We also have a Supreme Court decision is coming out on the retirement age conundrums. So that is expected to clarify a lot on the issue of retirement age. So that's kind of it. That's it so far. I mean, it's only February. It's the end of February. It's fast come in, but there's lots to look forward to.
Absolutely. There's loads there, Hilary. Thank you so much. We had a couple of questions. Are the WRC payouts subject to normal employment taxes?
It depends on, now that's more of a tax thing. It depends on what the award is. So if it's discrimination, I think it is tax free. But if it is because of pursuant to, like say, minimum notice, you pay tax as normal. So it would depend on what claim on what piece of legislation, Claire. But payroll will know that, or payroll should know. If it's, as I said, if it's minimum notice, then yes, that's taxable. But tax is not my thing.
You can't be great at everything, eh?
No, well, I stay firmly away from it. Can you circulate the slides following the session? Absolutely.
That's okay. Okay,
Yes.
guys. Well, look, Hilary, thank you so much.
Yeah, well, thanks for bearing with us.
Thank you. It's been another great session. We're hoping to do more sessions as the year goes through. So thank you to everybody who joined us today, too. I'll be sending feedback forms to everyone. Actually, I think one of my colleagues mentioned that there might be a feedback form that pops up when you exit the webinar. We will share the slide deck from today with everybody so you can review at your leisure, and feel free to reach out to me directly if I can be of any assistance in the future, and Hilary's contact details are also available. And if we're not connected on LinkedIn or anything like that, please do send us a connection. We'd love to include you in our network, and hope to see you all at the next one. Thank you so much.
Great.
Thanks, everybody.